Imagine you are sitting in the office of a listed company. You receive an email. The company is about to announce something that could move the share price dramatically. Maybe financial results, maybe a merger, maybe a major acquisition, maybe a dividend, maybe a change in capital structure. You know this information before the market knows it. Now you decide to buy the company shares. One simple question suddenly becomes extremely serious. Are you an investor or are you an insider? And if you are an insider, can you trade? Can you share that information? Can you tell your friend? Can your relative trade? And what exactly counts as unpublished price sensitive information? This is where the SEBI insider trading regulations begin. And today, we are starting a completely new master series. SEBI Prohibition of Insider Trading Regulations, 2015. Lecture 1. But I do not want you to learn this regulation like a dictionary. We are going to learn it like a story. A story about information, a story about access, a story about trading, and ultimately a story about one simple question. Who knew what and when did they know it? Welcome to Corporate and Securities Law Compass, navigating the law with clarity. This is the SEBI Insider Trading Master Series. Lecture 1. Today you will learn. Today we are starting with Chapter 1, Preliminary. We will first understand Regulation 1, short title and commencement. Then we enter Regulation 2, definitions. And this is where today's real learning begins. We will understand the meaning of Act, Board, Compliance Officer, Connected Person, Generally Available Information, Immediate Relative, Insider, Promoter, Promoter Group, Securities, Specified, Takeover Regulations, Trading, Trading Day, Unpublished Price Sensitive Information, and several other connected definitions. But most importantly, we will understand why these definitions are connected. Because if you misunderstand one definition, your entire insider trading analysis can go wrong. The story begins. Let us imagine a listed company, ABC Limited. ABC Limited is preparing its quarterly financial results. The results are much better than the market expects. But the results have not yet been disclosed to the stock exchange. The information is sitting inside the company. The CFO knows, the CEO knows, the company's secretary knows, certain directors know, certain employees know, the auditors may know, some professional advisors may know. Now imagine one employee receives this information. He calls his friend. He says, ABC Limited is going to announce excellent results. Buy the shares tomorrow. The friend buys the shares. The market receives the results 2 days later. The share price increases. Now ask yourself, where is the problem? The friend may say, I am not an employee of ABC Limited. I am not a director. I am not a promoter. So why should insider trading law apply to me? And this is exactly why Regulation 2I so important. Regulation 1, short title and commencement. The regulations are called the Securities and Exchange Board of India Prohibition of Insider Trading Regulations 2015. The regulations came into force on the 120th day from the date of publication in the official gazette. This may look like a basic provision, but remember, every regulatory framework begins by establishing its identity and commencement. And now we move to the heart of today's lecture. Regulation 2, Definitions. The opening words of Regulation 2 are extremely important, unless the context otherwise requires. The words, expressions, and derivations used in the regulations have the meanings assigned to them. That means something very important for you as a company secretary. Do not automatically apply the ordinary meaning of a word. First, check whether SEBI has given that word a specific regulatory meaning. This principle will follow us throughout the entire Insider Trading Master Series. Act. The first definition is Act. Act means the Securities and Exchange Board of India Act 1992. So whenever you see the word Act in these regulations, remember it refers to the SEBI Act 1992. Board. Board means the Securities and Exchange Board of India. In simple language, SEBI. So when the regulation gives a responsibility to the board, you know who the regulator is. Compliance officer. Now we reach one of the most important definitions for a company secretary. Compliance officer. The regulation refers to a senior officer who is designated as the compliance officer and reports to the board of directors. The person must be financially literate and the person must be capable of appreciating the requirements for legal and regulatory compliance under these regulations. But the definition does not stop there. The compliance officer has important responsibilities. Compliance of policies and procedures, maintenance of records, monitoring adherence to rules for preservation of unpublished price-sensitive information, monitoring trades, and implementation of the codes specified under the regulations. All of this operates under the overall supervision of the board of directors or the head of the organization as applicable. Think about that. The compliance officer is not merely the person who files forms. The compliance officer is sitting at the center of the information control system. Financial literacy. The regulation explains financially literate. It means a person who has the ability to read and understand basic financial statements, balance sheet, profit and loss account, statement of cash flows. Why is this requirement important? Because insider trading compliance can involve financial information, financial results, corporate actions, capital structure, business transactions, and other information that may become price sensitive. So the compliance officer must be capable of understanding the financial context of the information being controlled. Now return to ABC Limited. The compliance officer receives a draft financial result. The result has not been disclosed. The compliance officer knows that the information may be sensitive. What should happen next? The compliance officer must understand who has access, where the information is stored, who can receive it, whether the information qualifies as UPSI, whether the trading window should be closed, whether trades need monitoring, and whether the information has been properly preserved. Now we understand why the compliance officer definition is so important. Now we reach one of the biggest definitions in the entire regulation. Connected person. A connected person is not simply someone who works for the company. The definition is much broader. It covers a person who is or has during the 6 months prior to the concerned act been associated with the company directly or indirectly in any capacity. That association can arise through frequent communication with officers, a contractual relationship, a fiduciary relationship, an employment relationship, being a director, being an officer, being an employee, or holding a position including a professional or business relationship with the company. The important question is, does the relationship allow the person direct or indirect access to UPSI, or is the person reasonably expected to have such access? Notice the change in thinking. SEBI is not asking only, What is your job title? SEBI is asking, what relationship do you have with the company? And can that relationship give you access to UPSI? That is a much broader compliance approach. Practical example. Suppose ABC Limited appoints a legal advisor for a major merger. The lawyer is not an employee. The lawyer is not a director. The lawyer is not a promoter. But the lawyer receives confidential information about the merger. Can we simply say he's an outsider? So insider trading law does not apply? No. The relationship and access to UPSI become important. This is why the definition of connected person is relationship based and access based. 6-month look back. There is another important point. The definition refers to a person who is or has, during the 6 months prior to the concerned act, been associated with the company. So, when reviewing a potential insider trading situation, do not look only at the person's current relationship with the company. You may need to look backwards 6 months. This is why maintaining proper records of persons with access to UPSI becomes important. Deemed connect. The regulation then provides categories of persons who are deemed to be connected persons unless the contrary is established. This is extremely important because SEBI does not expect the company or regulator to start from zero every time. Certain relationships create a legal presumption, and the person may have to establish otherwise where applicable. Immediate relative. The definition includes an immediate relative of a connected person specified under the relevant provision. This means the family connection can become relevant. Why? Because information can move through personal relationships. Imagine the CFO receives UPSI. The CFO tells a spouse. The spouse trades. The spouse may say, I do not work for the company. But the regulation recognizes the importance of the relationship. That is why immediate relatives become relevant in the connected person framework. Holding company. A holding company can also fall within the deemed connected person framework. Think about the logic. Suppose ABC Limited has a holding company. Important strategic information may move between the entities. Therefore, the regulatory framework recognizes the corporate relationship. Associate and subsidiary company. Similarly, associate and subsidiary relationships are relevant under the deemed connected person framework. Again, the regulation is trying to identify where information can realistically travel. Intermediary. An intermediary, as specified under the SEBI Act, or an employee or director of such intermediary, is also covered within the specified deemed connect ed person categories. Think about merchant bankers, brokers, investment advisors, other market intermediaries. These people may receive confidential information in the course of their professional activities. Therefore, their relationship with the information becomes critical. Investment company and asset management company. The regulation also identifies investment companies, trustee companies, asset management companies, and relevant employees or directors. Again, the principle remains the same: access, relationship, information. Stock exchange officials. Officials of a stock exchange or clearinghouse or corporation are also included within the specified categories. Why? Because market infrastructure institutions can come into contact with sensitive information. Mutual fund connection. The regulation also refers to members of the board of trustees of a mutual fund and members of the board of directors of the asset management company of a mutual fund and relevant employees. Again, the focus is on the potential information connection. Public financial institution. Members of the board of directors or employees of a public financial institution, as defined under the Companies Act, are also included in the specified categories. Self-regulatory organization. An official or employee of a self-regulatory organization recognized or authorized by SEBI is also included. Banker of the company. Now think about a company approaching its bank for financing. The company provides confidential financial information. The banker receives that information. Can the banker simply be treated as an ordinary outsider? The regulation specifically recognizes the banker of the company within the deemed connected person framework. 10% interest test. The regulation also includes a concern, firm, trust, Hindu undivided family, company or association of persons where the specified persons have more than 10% of the holding or interest. This is another important compliance concept. You need to understand not just the individual person. You may need to examine the entity connected with that person. The important note. The regulation contains an important note. The intention is that a connected person is one who has a connection with the company that is expected to put that person in possession of unpublished price-sensitive information. This sentence gives us the philosophy behind the definition. The law is not merely looking at job titles. It is looking at information access. Generally available information. Now we come to another critical definition. Generally available information. It means information that is accessible to the public on a non-discriminatory basis. The regulation also clarifies that information published on a platform such as the stock exchange would ordinarily be considered generally available. Why does this matter? Because if information is already available to everyone, it is not the same thing as secret information available only to selected persons. This distinction is fundamental to understanding UPSI. ABC Limited has not yet announced its financial results. The CFO knows, the compliance officer knows, the board knows, the market does not know. That information is not generally available. Now the company announces the results through the stock exchange. The information becomes publicly accessible. The information is now in a different regulatory position. So timing matters. Before disclosure, after disclosure. This distinction is critical. Immediate relative. Now we move to immediate relative. The definition refers to a spouse of the person. It also includes parent, sibling, and child of the person or of the spouse where the applicable financial dependency or consultation condition is satisfied. The important point is that the relationship is not simply based on family connection. The definition also considers financial dependence or consultation in taking decisions relating to trading in securities. Practical example. Suppose a director receives UPSI. The director's spouse is financially dependent on the director. The spouse purchases shares shortly before the announcement. Now the compliance team cannot simply say the spouse is not a director. The relationship must be examined under the definition of immediate relative and the broader insider framework. Insider. Now we reach the word everyone has been waiting for. Insider. The regulation defines an insider as a connected person or a person in possession of or having access to unpublished price-sensitive information. This is extremely important because you can become an insider through two routes: connected person or possession or access to UPSI. The big lesson. You do not have to be an employee to be an insider. You do not have to be a director. You do not have to be a promoter. If you are in possession of or have access to UPSI, the insider definition can become relevant. Practical example. Imagine a consultant receives UPSI during a transaction. The consultant has no employment relationship with the company, but the consultant has access to UPSI. The analysis does not stop because the consultant is not an employee. The insider definition looks at possession or access to UPSI. Now ask yourself, what makes information special? The answer takes us to UPSI. Promoter. The regulation refers to promoter with the meaning assigned under the applicable SEBI framework. So remember, do not automatically assume that promoter simply means founder. The regulatory definition must be checked. Promoter group. Promoter group similarly has the meaning assigned under the SEBI framework. This becomes important because promoter and promoter group can have significance under several securities regulations. In insider trading compliance, the relevant relationship may also affect the identification of persons who require monitoring or disclosure. Securities. The term securities has the meaning assigned under the Securities Contracts Regulation Framework. Again, this is an example of a cross-reference. SEBI regulations do not always reinvent definitions. Sometimes, one regulation depends on another legal framework. Specified. The regulation defines specified as specified by the board in writing. This may look simple, but it reminds you that certain regulatory determinations can be made through SEBI's specified framework. Takeover regulations. The regulation refers to the SEBI Substantial Acquisition of Shares and Takeovers Regulations 2011 and amendments. This is an important connection. Insider trading compliance does not exist in isolation. It connects with takeover regulations. And that is why a corporate law professional needs to understand the wider SEBI framework. Trading. Now comes another critical definition. Trading. The regulation defines trading broadly. It includes subscribing, buying, selling, dealing, or agreeing to subscribe, buy, sell, or deal in securities. And trade is to be construed accordingly. This is important because insider trading analysis is not limited to a simple purchase of shares. Why the definition is broad? Imagine an insider does not sell the shares. Instead, the insider enters into another type of transaction involving securities. The definition of trading is designed to capture a broader range of activities. So do not assume no purchase, therefore no trading. Always examine the regulatory definition. Trading day. Trading day means a day on which the recognized stock exchanges are open for trading. Simple, but important, because several compliance timelines can depend on trading days. Unpublished price-sensitive information. Now we reach the heart of today's lecture. UPSI. Unpublished price-sensitive information. The regulation defines UPSI as information relating to a company or its securities, directly or indirectly, that is not generally available and which, upon becoming generally available, is likely to materially affect the price of the securities. Read that carefully. There are three important ideas. Information, not generally available, potential material price impact. The three-part test. When you receive information, ask three questions. Is it information relating to the company or its securities? Is it generally available? And if it becomes generally available, Is it likely to materially affect the price? If the answer points towards UPSI, you need to activate your insider trading compliance thinking. Examples of UPSI. The regulation specifically includes several categories: financial results, dividends, change in capital structure, mergers, demergers, acquisitions, delistings, disposals of units or business divisions, expansion plans, new projects, major changes in policies or operations, agreements that may impact management or control, fraud or defaults, changes in key managerial personnel, resolution plans, restructuring, one-time settlements, admission of winding up petitions, admission of applications under insolvency law, initiation of forensic audits, financial misstatement, misappropriation or siphoning of funds, actions initiated or orders passed by regulatory or statutory authorities, outcomes of litigation or disputes, guarantees or indemnity, material events specified under the applicable listing framework. This list is extremely important. But remember, the definition is not simply a list to memorize. The core test remains whether the information is not generally available and is likely to materially affect the price. Financial results. Let's take the first example. Financial results. ABC Limited has prepared its quarterly results. What about a trading plan? What happens when UPSI is communicated for a legitimate purpose? And who is responsible for maintaining the structured system that prevents misuse of UPSI? Those questions take us beyond definitions. That is where the actual prohibition begins. And in our next lecture, we will enter Regulation 3, Communication and Procurement of UPSI. We will understand when communication of UPSI is prohibited, when communication can be legitimate, who can receive UPSI, what is a legitimate purpose, and most importantly, what happens when an insider trades while in possession of UPSI. This is where the real insider trading story begins. If you want to understand SEBI insider trading regulations from the definitions to practical compliance, subscribe to Corporate and Securities Law Compass. Navigating the law with clarity. This is the SEBI Insider Trading Master Series. Lecture 1. Do not just memorize the definition. Understand the information, understand the relationship, understand the access, and understand the timing. Because in insider trading law, information is power. But possession of that information can also create responsibility. I will see you in lecture 2.